Representative DuBuisson on your bill.
Thank you and good morning, Chairman Marino and members of the Criminal Justice Committee. I know you've been anxiously awaiting my bill, HB 461, so I'll begin. But before I do, I'd like to ask personal privilege, if I may, Chairman.
Yes.
I'd like to take a moment to welcome my former assistant, Jenny Dexter, and the Louisiana Recreation and Park Association. That is, she is here for. So, please stand. Thank you. Thank you. Thank you, Mr. Chair. I understand this is one of the most controversial topics we may address this session, as it has been in previous sessions, and I'm sure will continue to be. Since abortion became a state issue and our abortion ban went into effect, doctors have been faced with various restrictions, ones we intended, and the confusion, misinterpretation, and fear we did not. As a result, women carrying dead babies will be forced to carry them to term, even at risk to their personal health. I understand the reasons why this is so politicized and why legislators must sometimes think in absolutes. However, this gray area is what we need to focus on now. This is not about abortion, government, choices. This is about both compassion for women who are in the midst of probably the most horrific experience they may ever face, and it is about women risking death if a medical physician does not intervene quickly. Some of you may have seen the 60 Minutes episode or read the news stories, social media articles, and heard the testimonies last week. We have a real problem. We are not protecting mothers. We are leaving them to hemorrhage and carry a dead child until they pass naturally. Well, I'm here today as a voice for those women by saying there is nothing natural about leaving a doctor's office or a hospital with a dead or dying baby inside of you and knowing you may die before giving birth to the baby because of infection, hemorrhaging, or other medical emergencies. There is nothing natural about the government making decisions over physicians in this situation. You may say the physicians do not know how to interpret the law we passed last year. I may agree with you if it were only for a few. However, when it results in what we have seen over the past year, that tells us if the collected group cannot understand a law, then we are failing in our wording of the law. This bill shouldn't be a partisan issue nor a gender issue, but perhaps only a woman could truly understand what it feels like to have a life growing inside of her and then to no longer feel that life. My own mother, now 93 years old, had her last baby die before giving birth. She knew something was wrong, but didn't know what. She carried her baby to term. However, she didn't get to hold her or even see her. She could have died from the complications I mentioned above. Thank God she came home to her 5 children, but without my sister. Thankfully, I have never miscarried, but even though I was very young, I remember the pain our family experienced. Science has come a long way since then, but have we really? Tying the hands of physicians and allowing a woman to suffer unnecessarily is heartless and cruel. To not address this issue is telling these women and physicians we don't think they matter. Colleagues, this bill will not enhance access to abortion. On the contrary, it will keep our pro-life position in Louisiana. What it will do is eliminate the requirement that women carry dead fetuses to term. This bill will not allow women to abort healthy babies. It will allow women carrying wanted children who die in utero to have these life-threatening fetuses removed without penalty to themselves or their physicians. I am and always have been pro-life, but that also means I cherish the lives of women who have wanted pregnancies that are non-viable. Mr. Chairman, since the Louisiana Right to Life organization only appears to object to the term non-viable being undefined, I would like to propose an amendment to make that correction and allow their support of this legislation.
All right. Which amendment set are you referring to?
2973.
Okay. Yeah, that. Okay. I will offer amendment set 2973. Attorney Gonzalez.
Thank you, Mr. Chairman. This is Amendment Set 2973, and as Rep. DuBuisson stated, this set of three amendments, the first two make technical changes. The third amendment defines the term non-viable to mean the stage of fetal development when, in the judgment of the physician, based upon the particular facts of the case before the physician, and in light of the most advanced medical technology and information available to the physician, there is not a reasonable likelihood of sustained survival of the unborn child outside the body of his mother with or without artificial support.
Okay. Representative Seabaugh.
My question is on the amendment. I thought we had a rule that amendments had to be made public the day before so that we wouldn't get substantive amendments sprung on us like this. I just want to clarify and just confirm that we do have two sets of rules.
No, we don't have two sets of rules. We have one.
We just enforce it separately.
Well, you didn't let me get to that part. I'm assuming you're objecting to the amendment because it has not been published.
Not yet. I haven't read it yet. I'm just objecting to the procedure, but go ahead.
And I'm not disagreeing with you. That is our procedure. That is our procedure that we've done, and we go. I've been trying to enforce that straight down the line. That I do not want to accept amendments that are substantive amendments during committee. So I'm going to say that if you intend to offer this amendment, I would suggest you do this between now and the floor and not right now, because I agree with Representative Seabaugh.
Thank you.
That I don't want to take a substantive amendment that the committee is not, or the public has had an opportunity to discuss. So we're going to go forward with the bill as in its present form. And that would be your option or anyone's option between now and the floor to offer this amendment. So
Mr. Chairman.
All right. So we are back to the bill. Okay. Now, Representative DuBuisson, do you have witnesses that you would like to speak that are with you at the table at this time?
I do. This is Ellie Schilling.
Yes. Good morning. I'm Ellie Schilling. I mostly intended to come to the table just to answer any questions. You guys had a lot of questions.
Did you fill out a card?
I did, yes.
Okay.
You had a lot of questions with the last bill. And there's physicians and patients who are going to testify in terms of putting this in context of their lived experience as doctors and physicians. But I'll just start out maybe by clarifying a few things in terms of the legal aspects of the bill. For one, then the amendment in terms of adding the definition of non-viable to the law, there is already a definition of viable and viability in the statute. 87.1 defines that. And so the proposed amendment is just the reverse of that. So it's already very clear in the law what viable and non-viable means. Second, in terms of some of what we've heard before about the current exception for miscarriage management and what needs to be clarified. The language of the law now says that a physician can intervene and take care of a woman and provide whatever care is necessary if the diagnosis is that the pregnancy has ended or is in the unavoidable and untreatable process of ending. And as you'll hear from physicians, that's not medical terminology. And so that's a lot of what the difficulty has been, is interpreting what that means. So that portion of the bill is simply an attempt to take that non-medical barrier that's qualifying the miscarriage management care out of the exception and allow the physicians in their medical judgment to treat patients as they normally would and when they're in the process of a miscarriage. And then you also heard some testimony earlier about the second aspect of what the bill tries to do in terms of serious pregnancy complications that will render the pregnancy non-viable, meaning that it's happening before viability and the complication is so severe that the pregnancy will not continue to viability. Some of the testimony before was, though, that there's already a health and life exception of the mother in the law, and that's true. But at this point, in terms of physicians deciding when and if they can treat a patient, they have to wait until the patient is about to die or is about to suffer a permanent impairment to a major bodily organ. So this is an attempt to clarify the law that if you have a patient that is in the middle of a serious pregnancy complication like that, you do not have to wait for her health condition to deteriorate before you can provide necessary care.
Thank you. Okay, the board is clear. I do have your card. All right, so I have more speakers that are present and would like to, Representative Knox, do you have a question for these, not the bill author, the witness? You have a question for the witness? Okay.
Yes. Hi, and again, I'm sorry, and I apologize about my ignorance. I'm trying to understand the current law that we have and understand what it is that you think need to be done to clarify it. So as I understand it, if a woman is pregnant now with a non-viable baby, if a procedure was to happen is to, I guess, remove the baby, for lack of better terms, is that or is that not considered abortion? And does this fall on the list that was previously referenced to?
So a lot of the confusion here in terms of what care
Yes.
can and can't be provided is because the actual procedure that would be used for a miscarriage or for certain types of pregnancy complications is the same. It looks the same as with an abortion. So either through medication or through, excuse me, the type of surgical procedure. So that's what the concern is with physicians, is that when they're going to render that type of care, is their patient in one of these narrow sets of circumstances that the law currently carves out to say that that specific thing is not an abortion? And what we're saying is that those narrow and non-medically defined exceptions now are confusing, and they're not accounting for the range of circumstances that physicians and patients find themselves in terms of the process of a miscarriage or of other serious pregnancy complications that are going to mean that you can't carry to term. The list that you're talking about is a different part of the law.
Okay.
That's a totally different part of the law that has to do with diagnosing fetal abnormalities. So LDH has a list of conditions. That's a different part of the law. This bill does not address that.
So, and I'm going to wrap up, Mr. Chairman. Can you give me, it was referenced that Representative DuBuisson mother had to carry the baby to full term. How common is that, and how does that work? How does that fit? How does that feel to a woman physically, I guess? And we could talk about the psychology of it, but the physicality of it, to carry a non-viable baby to term. Because when you say to term, in my mind, I'm thinking 9 months. But also in my mind, my logic tells me if it's a non-viable baby, the baby isn't growing. So what does that mean to carry a non-viable dead baby to term?
So there will be several physicians that are going to testify that can probably answer that for you more specifically. But from a legal standpoint, then that's the sort of the problem. There's all kinds of different things that can arise at different stages of pregnancy that will render that pregnancy incapable of going forward to full term. So if it's something that happens earlier, which is what this bill really is dealing with, then, you may go into very, very preterm labor. And there will be serious risk to your own health if there can't be appropriate interventions in care. There's other situations that as you said, that the fetus may not be developing, but you could still go full term, but knowing then, like, for example, in instances of stillbirth that can happen later in pregnancy. So that can take a variety of forms. And this bill is really just trying to address the miscarriage management and pregnancy complications that occur pre-viability that will make it so that the pregnancy will not survive to term.
Thank you.
And if I may,
Well, let me just keep going. We got a lot of more people that want to speak, so we can try to get all the people to speak first, and then we'll come back to you and let you answer questions. Rep. DuBuisson, I don't want to interrupt you, but I've got a stack of cards of people that want to speak on this bill. If I could ask, the board is clear for this witness. No, the board is not clear. Vice Chairman Bakala.
I just want to call to your attention that, we have the two-physician rule for the viability of the child, but not a two-physician rule for the health of the mother. And to quote the law, it says, the performance of a medical procedure necessary in good faith medical judgment or in the reasonable medical judgment to prevent the death or substantial risk of death to the pregnant woman due to a physical condition or to prevent the serious permanent impairment of life-sustaining organ of the woman, et cetera, is an exception. So I think a single physician acting in good faith medical judgment or reasonable medical judgment, there is no issue here. I don't know how much more clear we can get than that, except saying a doctor, a physician, can make a medical judgment that is reasonable to perform an abortion for the life or health of the mother. Where is there not clarity there?
Representative Bakala, if I may. So we wouldn't be at this table dealing with this difficult issue today if it was so clear. The reason why we're here is because many, many people, and I might say, Representative Horton, you said you represent your people in your area. So in your area, maybe these doctors don't have any question about it. But obviously, there are enough that are concerned that are leaving Louisiana and afraid to even go to medical school and major in OBGYN.
I don't mean to interrupt you, but if you have a question for the witness, we will have a chance to question the bill author, and she will have an opportunity to respond. I'm just trying to get through the cards first. I know that
Thank you,
questions.
Mr. Chairman.
Thank you. Okay, so
I can respond very briefly.
Very briefly.
The bill is not amending that section of the law in terms of the life and the health of the mother, Representative Bakala. The purpose of the bill is to allow physicians to be able to provide appropriate and timely medical care before a patient is in that dire situation, if that's otherwise where the situation is going.
Okay, thank you. I'm going to read the cards, and let me know if you're here, because we're going to try to put 3 people up at a time. Present and would like to speak. Jennifer Avegno, present and coming forward. Marianne Mushat, come forward. James, Kian, is it Louisiana Physicians for Patients? Is this person here? Can't read your last name. All right, we're going to move past that one. That's 2 cards, same person. How about Frankie Robertson? Frankie Robertson present. All right, so we have 3 people. Again, members, what we're going to try to do is let each of these witnesses speak, and then when we have questions, we'll go to questions after each has had their 3 minutes. And who would like to be first? Yes, ma'am.
My name's Mary Ann Mushat. I'm from New Orleans. And when I was in grad school 20 years ago, I was recently married and was very happy to be pregnant. However, on a routine prenatal visit, I had an ultrasound, and they put the microphone on the belly and you hear the baby's heartbeat. Well, mine had nothing. My baby was non-viable and I had a miscarriage. And the medical treatment that I received was immediate, professional, and caring. And then it allowed me to recover and grieve. And then when I was pregnant again, I was able to face that pregnancy knowing that no matter what happened, I would be okay, my health would be guaranteed, and I could move on. And my older son is now 24, college graduate, happily employed. And when I was pregnant again, I had the same situation. However, because of the care I received, which was immediate, professional, and caring, I was able to face it and then got pregnant again. And my second son is now a junior in college. And I just, and also I remember when I was a child, I'm not going to tell you how many years ago that was, but I remember my mom coming home. She was supposed to be coming home with a baby, and she didn't because she had a miscarriage. But again, her care was immediate, professional, and caring. And I just would ask you, especially in light of the abysmal maternal health record that Louisiana has, to consider and support this bill. Thank you.
Thank you.
Hi again, Dr. Jennifer Vegna, Emergency Medicine from New Orleans, and I'm here to urge you to support House Bill 461. I know I've made some of my points in the previous bill, but I do believe that this bill is critical to ensuring medical providers can provide timely and potentially life-saving medical care to pregnant patients, particularly those who are experiencing challenges due to pregnancy complications. Again, we cannot overstate the fact that Louisiana has some of the highest rates of maternal morbidity and mortality in the country, and a third of our parishes are OB care deserts, meaning that women have no access to pregnancy care nearby. So emergency departments, which fortunately, thanks to expansion, we have plenty of emergency departments all over. These are often the first place they seek health care and go for life-threatening conditions. Emergency physicians use medical judgment and years of experience every day when considering the most advisable and appropriate course of treatment. We train for years. We are strictly required by licensing requirements to stay up to date on the standard of care. And in over 20 years of practice, I know that every patient, particularly those experiencing the range of pregnancy complications, presents differently and requires that expert diagnosis. The current law, in speaking with physicians from across the state, is causing fear and confusion because it impedes the provision of timely and appropriate care, and it disregards standard of practice for patients in the process of a miscarriage or other pregnancy complications. Like I mentioned before, if we're talking about life-saving measures, we don't want to have to get to the point where we are acutely intervening because someone is crashing in front of us. If you diagnose a miscarriage or pregnancy complication, you want to treat it early, not only so that the woman does not deteriorate, but so that you preserve her future fertility. The lack of clarity and the lack of ability to use good faith medical judgment, as is being proposed in the current law, creates confusion in rural and urban settings alike and is delayed care for women. Waiting until a miscarriage turns into a, quote, real emergency means women suffer. We've been trained to handle complications, but when we fear that our actions could be misinterpreted as providing an elective termination, anybody is going to be disinclined to act if their liberty and their livelihoods are threatened. We've seen this fear play out. We've seen a significant increase in transfers to our urban specialty centers, again, where we do have the benefit of having multiple physicians of patients with pregnancy complications, because Those in areas without robust physician coverage are afraid their decisions will be second-guessed or, quote, the patient wasn't quite too sick enough. And so they'll transfer them, and that delay worsens care. This is not good medicine, and it puts our local doctors, who are mostly Louisiana natives, in a terrible position. This bill would help to alleviate these problems by allowing healthcare providers to truly use their medical
I'm not-
judgment. Thank you.
I'm sorry,
No,
you're
thank
over
you.
the time. Yes, ma'am.
Good morning. My name is Frankie Robertson, and I'm here providing testimony on behalf of Dr. Tanya Hawkins Hunter. Her testimony reads, my name is Dr. Tanya Hawkins Hunter. I'm an African-American OBGYN, born, raised, and trained in Louisiana. I've practiced in the most poverty-stricken, underserved areas of our state for over 25 years. I'm a mother of 3 adopted children because as a young woman, I experienced a life-changing early pregnancy complication causing infertility and the inability to bear children. During my 2 pregnancies, both resulted in doctors making life-saving decisions that, if made today, could result in them being jailed, fined, or unable to practice medicine ever again, or even more, with me being dead. My first pregnancy was complicated by huge melon-sized ovarian cysts. At 20 weeks of pregnancy, I was in severe pain, carrying the baby and 2 watermelon-sized cysts. I could not walk, go to the bathroom, or eat. I gained 75 pounds. I ended up having surgery to remove the cyst, and things took a turn for the worst. I became septic after the surgery and had multi-organ and respiratory failure. My kidneys shut down, and I could not breathe. My doctors were able to make the decision to deliver a non-viable 21-week pregnancy in order to save my life. I spent 2 weeks in the hospital on a ventilator in florid sepsis, and I nearly died. I'm only here due to the life-saving decisions made and procedures performed by my OBs, oncologists, and high-risk specialists. I went on to finish medical school and residency and started practicing near my rural hometown. My second pregnancy was achieved several years later using assisted reproductive techniques. We underwent extensive and expensive fertility treatments and ultimately conceived twins. I carried the twins to 22 weeks and was diagnosed with cervical incompetence and preterm labor. I required in-house hospitalization on bed rest for 3 weeks. I went into labor and delivered 1 baby at 22 weeks and had an emergency stitch placed, hopefully to keep the second baby in place until viability. Unfortunately, I again became septic with fever and multi-organ failure, prompting my doctors to make the decision to perform an emergency C-section, knowing the baby would likely not survive from being born too early. The baby did die at only a few hours old, but because of the expertise of my physicians, I recovered and I went on to practice as an OBGYN for over 20 years, taking care of patients who look just like me. During my time in practice, I made decisions many times to save the life or protect the health of a patient that unfortunately resulted in pregnancy loss as a consequence of the medical decision-making. I made those decisions with competency and compassion, just as I was trained to do in emulating doctors who saved my life twice before. Now, under the current law, if any of us made those same medical reasonable decisions, they could later be interpreted as running afoul of the law, and we could be jailed for up to 10 years or more, face fines up to $200,000, or our license would be revoked, and we can never practice medicine again. I live in rural Louisiana, where a physician shortage is here, especially of OBGYN physicians. A recent episode of 60 Minutes highlighted this information. Thank you.
Thank you, Ms. Robertson. Okay, the board is clear. I'm going to call up the next 3 witnesses that are present and wishing to speak. Gwyneth O'Neill, Ms. O'Neill, Helen Frank, and Matilda Silverberg. Okay.
It's a hard one.
I forgot to mention that at the beginning. Please print your name very carefully so that the chair can read it. Yes, ma'am.
Good morning. My name is Gwyneth O'Neill, and I'm here to provide the story of a brave 34-year-old attorney and mother of an almost 2-year-old daughter named Matilda Stubblefield, who wanted to be here today but couldn't. These are her words. On Christmas morning, my husband and I felt incredibly blessed when we looked at a positive pregnancy test and cherished what we thought would be our last Christmas as a family of 3. Unfortunately, when I went to my first ultrasound appointment a few weeks later, something wasn't right. The doctor who delivered my daughter via C-section came into the room with heavy concern in her eyes. My pregnancy was 7 weeks along, but its final heartbeat was weak and the size too small. Worse, it was growing into the cesarean scar from my first pregnancy. The doctor said the chance to have a baby born alive was non-existent. Instead, as the pregnancy grew, it would most likely rip open the cesarean scar in my uterus. Best case scenario, I would get a hysterectomy to stop the bleeding and save my life. Worst case scenario, if I was not close enough to a hospital, I would bleed out and die. According to my doctor, this rupture could happen at any time, in the next 7 minutes, or in the next 7 hours, or in the next 7 months. I wanted a baby, not an abortion, but I did not want to gamble with my health, or my life. I'm married to an emergency room doctor who sees things go wrong every single day. Ultimately, when we chose to terminate our pregnancy because the wait and see what happens approach would have meant jeopardizing my ability to have more children and risking my daughter growing up without a mother. Please don't ask my family, my toddler, or anyone else to take that risk. I consider myself lucky because I was able to get the care that I needed. My doctors and nurses were willing to perform a medical procedure that under current law could be construed as a felony because my life and health were not immediately in jeopardy at the time. I want to be clear. I wanted a baby, not an abortion. I sit here today to plead for the next woman who does not know it yet, but who will need emergency care, emergency abortion care. That woman who might be your wife, your sister, your daughter, or your granddaughter. Her life should not be placed in danger because the state laws intimidated her physician to the point where she must wait until she's on the precipice of death to get the care she needs. Medicine does not have a one-size-fits-all approach. Doctors are often faced with making decisions instantly to save lives. Our healthcare system trusts that they have the education, the skills, and the training necessary to make those decisions. Please let them do so here. I'm asking you not to put women in a situation where they have to leave their home state and their support systems to get medically necessary care. I've heard nearly every one of you say that you are pro-life. So is this bill.
We're over time, Ms. O'Neill.
Thank you. Just please let doctors make these decisions.
Thank you. Who'd like to be next?
Yeah, I'm going to go. Hi, my name is Mathilde Silverberg, and I'm representing the Louisiana Public Health Institute. The mission of LPHI is to ensure that everyone has a fair and just opportunity to be healthy and well. So here to talk more about public health. First and foremost, Louisiana's maternal mortality, as most of us know, stands at 24.5 deaths per 100,000 live births. This is significantly higher than our national average at 17.4 deaths per 100,000 live births. This crisis is further exacerbated by the fact that 80% of pregnancy-related deaths in our state are preventable. That is 80% of pregnancy-related deaths are preventable. Among these deaths, over 2 Black birthing people die for every 1 white, highlighting the urgent need for supporting healthcare providers and offering comprehensive care. This includes miscarriage management. Secondly, 34.9% of Louisiana's parishes, as we've talked a lot about this morning, are maternity deserts, where people can't access reproductive health care services. Expanding reproductive health care is crucial in combating our state's maternal health crisis and ensuring pregnant people get the care that they need. Improving maternal health outcomes means we also need to focus on strengthening our healthcare workforce, which we've heard a lot about today. This means having more specialists in our state, and restrictive laws undermine our efforts to expand our healthcare workforce and jeopardizes our public's health by discouraging medical professionals from wanting to enter and remain in the healthcare field in our state. Our current abortion law is confusing, it is vague, and it's hindering our healthcare providers from effectively diagnosing and treating pregnancy complications and miscarriages. Our laws should allow our healthcare professionals to exercise judgment to provide appropriate individualized care based on their patient's needs. Denying medical care to pregnant individuals, especially when their health, fertility, and life is at risk, is a violation of fundamental human rights. Our medical associations emphasize the importance of physician discretion and individualized care in diagnosing and treating pregnancy conditions and miscarriage management. These decisions about people's lives and pregnant people's lives should be made between them and their provider, and current law is hindering that care. In closing, the Louisiana Public Health Institute supports this bill to offer clarity around the present law.
Thank you.
Good morning. I'm Helen Frank, and I'm reading on behalf of Angela Gornar. Good morning. My name is Angela Gornar. I'm a resident of Baton Rouge, and I would have loved to have spoken with you all in person this morning. However, I am currently 25 weeks pregnant with twins and on bed rest following severe complications. At 18 and a half weeks, I was diagnosed with twin-to-twin transfusion syndrome. This is a rare pregnancy condition affecting identical twins or other multiples. Without surgery, my chances of losing both babies was greater than 90%. Following a successful surgery in Houston, I was sent back to Louisiana to recover and was deemed high risk for the remainder of my pregnancy, knowing I could lose either or both my twins at any point since the pregnancy wasn't yet viable. 4 days later, on Easter morning, my water broke and I was rushed to Women's Hospital. There I was told that it appeared my water had fully ruptured and there was nothing that could be done except wait and see. When discussing our options, I was told the only option was to wait and see what happened and hope that my health didn't deteriorate into an actual emergency, because that was the only way they could intervene, regardless of whether I was already in fact in the process of losing the pregnancies. To say that we were terrified and confused about how ambiguous my medical treatment was is putting it mildly. We were sitting there, devastated, wondering how there was no set of medical course of treatment and no set protocol in place under the current law. Thankfully, my OB and maternal fetal medicine doctors requested I be admitted to be monitored due to my earlier surgery, and thankfully, I have the family support and medical insurance to make that possible. My situation could have turned out much worse. I was one of the lucky ones, but no one's medical care should come down to luck. In a state that has some of the best OBs in maternal fetal care, I was, and still am, baffled that I would have to potentially seek care from some physician in another state who does not know me, my history, or my chart, if I hadn't been so lucky. And even still, I would have been one of the lucky ones because I have the means and ability to travel. Please make the important and very modest changes to the law that are proposed by HB 461. No one in the middle of the crisis of a serious pregnancy complication should be forced to travel or forced to delay or forego care in the hopes that their health does not deteriorate to the point of an imminent emergency. Please allow Louisiana physicians to provide the timely and potentially life-saving care that patients need. Thank you.
Thank you. And the board is clear. Do we have a question? Representative Knox.
I do have a question, Mr. Chairman, but let me preface it by saying that when I made the comment earlier about being ignorant and being a man on this issue, I didn't say it to be funny or rhetorical. I really meant that, and I've been learning so much about abortion and the nuance of issues as it relates to it. My grandmother used to have a saying, and she didn't have much education at all. And one of the things I remember her saying as a young boy growing up was that a woman having a baby is like having one foot in a grave. And I never knew what that meant until these last 2 weeks. And I want to thank all the women who have come before this committee to educate me. I've been married for 20 years. My wife and I, unfortunately, haven't been blessed to have any children. And in sitting and listening to these conversations, it has been intriguing. It has been scary.
Yeah, I know.
And frankly, it's been very sad. And I regret the fact that we're having this conversation in the midst of an election. Because I think had it been a different time, the response to all these women who have come before us probably would be a little different.
Rep. Knox, I don't want to interrupt you.
I'm going to wrap up, Mr. Chairman. The question I
waiting
want
for
to
the
have,
question.
what does it do to the psyche of a woman to go through the experiences that I've heard over the past 2 weeks? Educate me as a man. What does it do mentally to you? Because I see some of you all look like you're still having what I call PTSD just by mentioning this conversation. So can you explain to me, please?
So I testified on, my testimony was provided by someone who couldn't be here today. But I can just tell you as a woman to not be able to be, there's no other system, there's no other place where we question the medical decisions of our doctors. It's not regulated in that fashion. So we've carved out this one tiny thing that's actually not tiny at all. It's very significant. It's not about choice. That's a false narrative that we're putting on top of this. This is about health care. This is about trusting that the people who go through medical school are the ones most qualified to make these decisions. Because respectfully, Representative Knox, I appreciate that you've been trying to educate yourself as people sit here in front of you. But the people who went through medical school, who went through residency, who are encountering these problems on a daily basis, what we're asking is that those be the people who are allowed to make those decisions with the women who are being affected by these complications. And so I can't personally answer your question, but I can tell you that if faced with it, I can only imagine how that would make me feel. To feel that I couldn't make that decision with my doctor, where for every other healthcare complication I had, I would be able to make that decision.
Thank you.
Thank you. And the board is clear. Do you have another question, Representative Knox? Okay. Let me turn. All right. So I have more witnesses that are present and wish to speak. Melissa Forney, Dr. James McNary, Dr. Nicole Freehill. And those are the last three green cards that I have that are present and in support and would wish to speak.
Good morning, Mr. Chairman. I'm Melissa Flournoy. I'm board chair of 10,000 Women, and I would like to thank the chairman for his compassionate handling of the hearings this week and last week. I'm here to support Representative Mary DuBuisson and her courage to speak for women who are pregnant and for doctors and the patients to come and talk about the need for medical care. I'm here to tell my mother's story. In 1963, my mother was pregnant with her third child. She knew something was not right with the baby. After many tests, her doctor told her that the baby was seriously malformed and basically had no head. He recommended termination. He said that he knew a doctor in Shreveport who would terminate the pregnancy, but it was illegal. My parents felt forced to carry that baby to term. She was stillborn. The grief of carrying that baby affected my parents for all of their lives. They chose not to have more children. My mother wished she had had the option to terminate that pregnancy. Here we are 60 years later, when we have the technology, the genetic testing, the information, the physicians, when we are able to protect women who are experiencing serious pregnancy complications, and we choose not to. I'm here to ask you to support this bill. We need to trust women, and we need to trust doctors, and we need to trust families. Thank you.
Thank you.
Hi, thank you. Again, Dr. Nicole Freehill, practicing OBGYN in New Orleans. I have a couple of points that I just wanted to bring forward. I think that for me and for all of the physicians that have supported this bill and that I've talked to about this bill, it is about clarifying a medical situation, and medical terminology for us is very important, because I can tell you, as a physician who is well educated, I have a lot of difficulty with not just lots of bills that are brought forward, but I'll give an example. Like when I was signing my contract for practicing, the legalese is very difficult, and lawyers are like, oh, what are you talking about? This is our language. This is how we speak. For me, same thing. I have a medical language that I speak, and I think having that medical language in a bill, especially one that's as important to clarify as a situation like pregnancy, I think that that's just hugely important. So that's part of the reason why I'm supporting this bill. I think it's important to point out that the number of applicants to OBGYN residencies decreased significantly in this past year. I don't think that that's a blip or a circumstantial thing. I think that a lot of medical students are scared about what's happening in our state and in other states, but particularly in our state, there has been a 10% decrease in number of applications to residency programs in our state since before these bills were enacted. And I think that over time, we're going to see the outcomes of our patients worsen because we're not going to have enough physicians here to take care of them. I think that there are some situations that are really hard to clarify, and Representative Knox, I think you brought it up, is, what does it feel like to go through this and to have these situations? I've been lucky myself. I've had 2 pregnancies, 2 healthy children. I did not go through any of these situations. I'm very happy that I did not. I think, though, having taken care of so many women who have been in these situations, and I'm sorry, it's hard not to get emotional, I myself have PTSD, and it was not me going through this. I have had friends and colleagues that I have had to tell them what is going on in their pregnancy and what is happening is not viable, and they're at risk and they're in danger. And I've cried with them and I've prayed with them, and it is not an easy situation for them. I can't even imagine what it's like for them because I personally have not been there. But I know I have a specific friend that I was talking to about this not long ago. Her pregnancy that I treated, that unfortunately had one of these complications that she had to deliver the baby early and not viable, she and I still cry every time I think about it. Even though she's had a healthy pregnancy after that, we still have PTSD regarding this, and this is not an easy issue. And I know my time's up. The clarity that comes in is just super important when it comes to medical terminology and treatments.
So, Doctor, my question is the same one that I asked you on the other bill. It's already in our law. Abortion shall not mean the removal of a dead unborn child. That part is already in our law. And in your opinion, are we expanding on what that means or clarifying what that means?
So I can think of situations that I think that we're clarifying. Like I previously said, physicians in our state, myself and other OBGYNs, know that elective termination of pregnancy, that is not what's happening. That is not what I've ever done. That I treat pregnancies that unfortunately have a complication that renders it non-viable, and that's the medical terminology. And that's what I think is important to put in this bill, because there are situations that are clarified already in the bill, or in this bill, in the law. Miscarriage, okay? There are other complications like medically futile, and we have a list of exceptions. I'm talking about there's another situation that's being addressed in this bill where you don't have what can be construed as what's in this law as a miscarriage or as one of these medically futile. There are other situations, and I think that this wording of that is in this bill tries to clarify that when you have a situation that's not clearly delineated already.
Would that be the the second sentence on the part that says, which is not considered to be an abortion, a medical procedure to treat a patient who in good faith medical judgment and certified in writing in the woman's medical record has been diagnosed with a complication that renders the pregnancy non-viable. Is that,
Exactly.
that's the language that helps?
Correct.
Thank you. The board is clear. Okay. Turn myself. All right. So we have, well, we had another person that wanted to speak, but we're moving along. That's a late card right now. We have 42 cards that are present in support of this legislation, and those will be placed into the record. I have 4 cards present in opposition and we wish to speak. Deborah Melvin, Ben Clapper, Dorinda Plaisance. Any order you like.
I'm Deborah Melvin from Thibodeau. And in reading the law, I also noted, Representative Marino, about the statement that is in our present law that says that abortion shall not mean the removal of a dead unborn child or the inducement or delivery of the uterine contents in case of a positive diagnosis. That also follows by saying that this would be certified in writing in the woman's medical record along with the results of an obstetric ultrasound test, and then it continues. That, from what I understand from reading the proposed law, would be removed. And it would
What
be
part of the law are you referring to as being removed? Which part?
the part that I just read, the removal of a dead unborn child or the inducement or delivery of the uterine contents in case of a positive diagnosis. But it also mentions along with the results of an obstetric ultrasound test.
So it's the, I don't mean to interrupt you. Go ahead, man. I'm on the same part.
Okay, and it replaces, the proposed law would remove that and replace it with the performance of a medical procedure. And there is no definition or explanation about what that medical procedure would be. And so that is a red flag to me. So if we're talking about a woman that is has been diagnosed with a non-viable pregnancy, if that section is removed from the law, that the removal of a dead unborn child or the inducement or delivery of the uterine contents, if that is removed, then to me, that's making that illegal. So I think we're going backwards with this. I find that our present law is very clear about what a non-viable pregnancy is, and I also would like to challenge everybody to really study what happens during an abortion procedure. And there is a very fundamental difference between delivering a child or having, even a miscarriage. There is a difference between that and an abortion procedure. So if you really want to learn, study what happens in an abortion. And I think, anyone with a heart would say that we don't want our children pulled limb from limb inside the uterus just because it's non-viable. But if that's an abortion procedure and that's done on a live baby and there's some kind of error made, then we're brutally killing a child. So study what those abortion procedures are during the first trimester, the second trimester, and the final trimester as to how abortions are accomplished. So I say that this language is vague, it's ambiguous, and I encourage you to vote no.
Thank you.
Dorinda Bordley, legal consultant with Louisiana Right to Life. In addition, as the doctor has stated,
Wait, is it Plaisance? Is that the same card?
yes, Plaisance.
Okay, just
Yes,
making sure.
Sorry.
Yes, ma'am.
Yes, sorry. Recently married, names might be confused.
Making sure I got
Okay.
a card with your name on it. Go ahead.
Yes, thank you. In addition to the ultrasound test being deleted, which is very important because when we are dealing with one physician making this decision. And so these protections in the law make sure that there aren't people performing abortions under the guise of miscarriage. And so if you can show that there is a legitimate reason and there's an ultrasound or a diagnosis that shows that, then that will be in the woman's record. It's very clear in our current law that a woman doesn't have to go to death's doorstep. All of those concerns are misplaced and misguided because our law says here, and it's in Section 5 of the exceptions, that the performance, this is not an abortion, the performance of a medical procedure necessary in good faith medical judgment. Good faith medical judgment is as broad as you can get to give the doctor the leeway he or she needs to prevent the death or substantial risk of death, or to prevent, life-sustaining impairments to life-sustaining organs. And so this gives the women this protection of good faith medical care, reasonable medical practice, reasonable medical efforts. It's through and through this law saying you decide what you need to do to make sure that both the woman and the baby are safe. And if you have to choose the woman's life over the baby, you try the best you can. And if not, then we understand this is life. Life is rough, and there are heartbreaking situations on both sides. But our law is clear. This bill opens up unending confusion because viability is about the child. This bill talks about non-viable pregnancies, which is not defined anywhere in the law. And so I just want to point out one thing. What is this about? We have to look at who supports the bill. This bill is supported by Lift Louisiana. They state on their website that their goal is to ensure abortion access. These amendments to our current law would allow abortion access, and we wouldn't know about it. We need to keep our eyes open. Thank you.
Thank you.
Mr. Chairman and members, thank you for your time. My name is Ben Clapper, Director of Louisiana Right to Life. When we first opened this bill, when it was filed, we read the word how this would lead to basically defining what's not an abortion is a situation when a complication renders the pregnancy non-viable. So we read this word non-viable. As you legislators know, laws are about words, right? That's how things are decided, and how people will follow laws are based on the words that are placed in here. So we read through here and said, okay, well, what does this legislation refer to when it's saying non-viable? Because it's not defined. Our abortion law has meticulous definitions to make sure that there's no unintended consequences. So non-viable is not defined in the bill. So what we did is we went into the code of abortion. It's actually in the same law. It's 1487.1.1. If you go all the way to the bottom, it defines viability or viable, the opposite of non-viable, because non-viable is not defined. So we wanted to see, well, what's the closest we could find to it? Well, viable means the stage of fetal development when, in the judgment of the physician and based on the particular facts of the case, before the physician, and in light of the most advanced medical technology, there is a reasonable likelihood of sustained survival of the unborn child outside.
Ma'am, you're leaning on the light switch. Yeah, push. No.
There is a reasonable likelihood.
Hold on, Ben. Put the light on and then move away from that. Push it up. All right, keep going. All right, please don't lean on that again. Go ahead. This is not counting in your time.
Oh, thank you very much, Mr. Chairman. There's a reasonable likelihood of sustained survival of the unborn child outside the body of his mother. So we're talking here about when the baby can live outside the womb, which, if you read ACOG's website, is about 23 weeks in this situation. So we read this and we said, well, it's not defined. The closest thing that we read here is that this bill is legalizing abortions before 23 weeks when the baby can live outside the womb. That's what the law said to us as we read it. Now, today, an amendment that was offered, and I know it wasn't debated or discussed, but it's still public record and it was referenced to Louisiana Right to Life, is that we go and we read this amendment and it says non-viable means the stage of fetal development, go on and on, so forth. There is not the reasonable likelihood of sustained survival of the unborn child outside the body of his mother, with or without artificial support. Mr. Chairman and members, I think this amendment makes very clear that the actual words of this bill, if passed, would legalize abortion before viability in this situation. That's what the words read to me. They're very clear in this situation, especially with the author's addition or suggestion of this amendment, that we believe if this bill is passed, as it is, it would legalize elective abortions before 23 weeks for a healthy unborn child, before the child has viability, which is defined generally around 23 weeks. We would oppose this bill because it would legalize abortion before 23 weeks of viability. Thank you.
Okay, we do have a question. Representative Horton.
Thank you, Mr. Chairman. First, I want to say thank you for everyone that's been here today. This is very difficult, and it's why we and I personally have read our current pro-life laws over and over again to see where is their confusion. It was said that by not supporting this bill, that we will force women to carry stillborn or unborn babies that are dead in the womb. We are forcing them to go through the agony of all the way to the delivery date. That is not what current law is. I remember when this law was being debated and amended over and over again to make sure that we did not pass a law that would agonize and bring more injury to our women. My mother had 4 miscarriages. I have many friends that have lost and had babies that were not viable, and it's agonizing for both. But talking about current law, our current law is sufficient. There's no confusion in the law. It gives us exactly the definitions we need, how to do it, and what's needed to be able to verify and protect the physician when they have to take a baby. So I want to ask you, do you agree with that position of what I'm saying?
Representative Horton, I would agree. I mean, I'm looking at the law as it stands right now. There was the claim that you said that women would have to be left with a dead unborn child in their womb. The law says what is not an abortion is the removal of a dead unborn child. But not only that, Representative Horton, the removal of a dead unborn child or the inducement or delivery of the uterine contents in the case when the pregnancy has ended or is in the unavoidable and untreatable process of ending. I mean, we are talking not only about the removal of the unborn child in this situation, but we're talking about the inducement of delivery of pregnancy when it's in the unavoidable and untreatable process of ending. I mean, the things that were said at the beginning of this committee hearing are not consistent with current law. The statement that was made that women have to somehow get to the moment before birth, it doesn't say that. I mean, moment before death, excuse me. It says to prevent the death, substantial risk of death, or prevent the serious permanent impairment. These are to prevent those things. The law provides all these things, and it's very clear about what is allowed and is not allowed in the law. And as the concern here, in the effort of trying to seemingly do this, what this law does, the words of this law, is opens up elective abortions for all babies before 23 weeks gestation.
Well, I really appreciate it because I just want to make it clear that whenever we did pass this law, and I know that all the debates that went on, we looked at every aspect of what could happen, what may happen, in order to make sure that no woman had to go through the agony of carrying a baby that was not viable, and I believe it's sufficient. So I thank you all for your testimony. Thank you, Mr. Chairman.
Representative Edmondson.
Thank you, Mr. Chairman. Thank you all for being here. Ms. Plaisance, is that what you said?
Yes.
Kind of to allude to what Representative Horton said, I know there was so much collaboration as we were developing our law. I just would like to know the input from the physicians to create our legislation. You mentioned a few. Can you just, in your own words, tell me who was involved in this?
Yes, through the years, we had Dr. Jack Andoni, doctors from the Louisiana State Medical Society.
Okay.
Those even who supported abortion, those who are, for and against abortion, we all came to consensus on protecting women's health when there's not, whether there is or is not an elective abortion. And so this has all been taken care of in this law, and I just want to point this out. There is currently a lawsuit that is challenging our laws. And because Roe is reversed, this is the case. This has gone back to the states. Louisiana has this law. We have the Love Life Amendment. However, if the abortion industry can prove to the court that this is confusing such that doctors don't know what to do, then the court would strike this down, and we would have abortion on demand through all 9 months of pregnancy here in Louisiana. That's the goal of an industry that is no longer practicing in this state. The truth is, these laws are so clear and concise that you don't see doctors and women knocking down the doors. If
That's what I'm
this was
concerned about.
unclear,
Are
you
we-
would have them.
Right. Are we really having physicians that are having angst with our law? That's what I want to know.
No, because we speak to them on the phone. I had a daughter that had a miscarriage recently, and there's no problems whatsoever. The spirit of fear and confusion that is being ginned up is in support of an abortion industry that is trying to get its foot back in the door.
Thank you. Thank you, Mr. Chairman.
Thank you. The board's, well, I have one question. If they were to put the obstetric ultrasound test back into the bill, would you be in support of this bill? Any of you?
Mr. Chairman, I think if they did that, it wouldn't change the things that I stated here, which is that this bill effectively legalizes abortion before 23 weeks gestation.
Yes, sir. Ms. Plaisance, would that change your opinion of the bill if we put the test back in that you said belongs?
I agree. I would not want an obstetric test and then allow them to abort the baby up to 4 or 5 months of pregnancy.
Okay. Thank you. All right, the board was clear. Representative Knox.
Sorry, Mr. Chairman. Thank you all for being here. I'm sorry, I don't recall your name, but you mentioned something about the industry and people trying to intentionally gin up confusion. Can you speak more to that and help me understand how is it that grieving mothers who've come before us and testified, how are they somehow part of some greater scheme to confuse and conflate what we're here talking about?
Thank you, Representative, for that question and for allowing me to clarify. There are so many women, mothers, doctors who have the best of intentions. They have heartbreak, they have compassion, they have genuine care. And they have been given information, misinformation, by those who, for the last 28 years that I have been in this body, have been supporting abortion clinics that have injured women and taken the lives of unique and unrepeatable human beings. And so when you have women who are told things that are not true, then of course they are concerned. When you have doctors that are told things and not given the actual law, because I can tell you if any doctor sat down with this law, one of the doctors that sat here last week said, and she was supporting one of these bills, she said, we have attorneys in our hospital and they have explained this to us, so I have no problems because I understand the law. However, some people may have fear or confusion. Well, if fear and confusion that we may have undermines a law, then we have no law, okay? And so please don't misconstrue my concern about an industry that has a monetary interest in the bodies of women and children.
Let's rein this back into this bill. We're going way...
To women who have legitimate concerns. And thank you for the question.
Thank you, but let's try to stick to the bill and not a much bigger discussion on the whole idea of it. I'm just trying to keep us on the bill. We got a little bit more to cover. I got another. Representative Knox, do you have any more questions? All right, thank you. The board is now clear. I have one more card in opposition who would like to speak, which is going to be Chris Alexander. Where are the other ones?
oppose the legislation, but we're going to pass.
He's going to change it to just a red card without speaking. We'll add him to the other list. There are 22 now other cards in opposition, not wishing to speak. I'm going to ask the bill author to come back to the table at this time. Rep. DuBuisson, if you would.
Mr. Chairman, I have a request since I am not a lawyer. Is it possible for Ellie to address some of the legal issues that were mentioned in the previous testimony?
Well, I'd like at this point, because what we try to do is we try to do cards in support, white cards, cards in opposition, then bring the bill author back. So I don't want to go back to testimony again from someone other than the bill author right now.
Okay, I understand.
And I don't have questions at this time on the board, so this would be the time for you to close.
Okay. First, I'd like you all to know that we have green cards from the American College of Obstetrics and Gynecologists and from the Louisiana State Medical Society. So I just wanted to mention that before I start. I just think, members, that it's very interesting that the bar continues to move with the Louisiana Right to Life. Look, I have the utmost respect for people on both sides of this issue, as I stated in my opening. It's a very difficult issue. But Ms. Plaisant mentioned that women's health is in the forefront of their decisions and how they run their agency. It's pretty difficult for me to believe that when you hear the testimony of women sit here and talk about people who are close to death because of having to carry a non-viable pregnancy. I know it sounds like I'm judging her. I'm just confused by that statement. And as I mentioned in my opening, that this bill is not to allow access to abortions. I'd like to just say that based on all the testimony on both sides of this issue, really, I guess at this point, there's nothing else to say other than I would respectfully request that you pass this bill favorably.
Yeah, I know, Rep. Marcel, but you pressed it after I said we have no questions and let her begin, and then she started speaking. So right now, where we are, I'm just saying that once we start closing, we don't, just like there was an additional card that came in at the very end that wanted to speak, but we had already moved past that. I'm not trying to shut off. I am going to move to report Representative DuBuisson's 461 favorably. And now we have a motion on the floor on that bill. And, well, push your button. All right. Okay, so I have made a motion to report favorably. Representative Horton.
I'd like to make a substitute motion to involuntary defer.
Okay. All right, so under the rules that we are going to need to take up the involuntarily defer motion first. At this time, Representative Horton has made a motion to involuntarily defer House Bill 461. Is there any opposition to involuntarily deferring the bill? I will object to that motion. We will have a roll call vote.
Representative Bakala?
Yes.
Yes. Representative Bryant? No. Representative Edmonston? Yes. Representative Fontenot?
Yes.
Yes. Representative Garofalo? Representative Gudo? Yes. Representative Hodges? Representative Horton? Yes. Representative Knox? No. Representative LaFleur? No. Representative Marcel? No. Representative Muscarello? Yes. Representative Seabaugh?
Yes.
Yes. Representative Villio? Yes. Representative Marino?
No.
No. 8 yeas, 5 nays.
Thank you.
Thank you, Chairman. Thank you, committee.